Welcome to literary and jury charge practice. Let's start out with some jury charge. Ready? Here we go. Fraudulent conduct may be in connection with the purchase or sale of a security if you find that the alleged fraudulent conduct touched upon a securities transaction on a national securities exchange. In this regard, the in connection with a purchase or sale aspect is satisfied if you find that Mr. Martoma used material non-public information for the purpose of securities trading, even though there is no evidence that other purchasers or sellers were harmed. Second element, knowledge, intent, and willfulness. The second element of the securities fraud offense charged in counts 2 and 3 that the government must prove beyond a reasonable doubt is that Mr. Martoma participated in a scheme to defraud, that is, the insider trading scheme alleged in the indictment, knowingly, willfully, and with intent to defraud. To participate in a scheme to defraud means to associate oneself with such a scheme with a view and intent to make it succeed. A person acts knowingly if he acts intentionally, deliberately, and voluntarily, and not because of ignorance, mistake, accident, or carelessness. A person acts willfully if he acts deliberately and with the intent to do something that the law forbids, that is, with a bad purpose to disobey or disregard the law. Intent. 2. Defraud in the context of securities laws means to act knowingly with the intent to deceive. For Mr. Martoma to have acted with the specific intent to defraud means that he must have known of the fraudulent nature of the scheme and acted with the intent that it succeed. Intent to defraud here means the intent to deprive Elon or Wyeth of the confidentiality of its information. The government need not show that Mr. Martoma, in addition to knowing what he was doing and deliberately doing it, also knew that he was violating a particular federal statute, but Mr. Martoma must have acted with the intent to help carry out some essential step in the execution of the scheme to defraud that is alleged in the indictment. It is not a willful, deceptive device in contravention of the federal securities law for a person to use his or others' superior financial or expert analysis, or his or others' educated guesses or predictions, or his or others' past practice or experience to determine which securities to buy or sell. Nor is it a deceptive device in contravention of the federal securities laws for a person to buy or sell securities based on public information or on tips where he does not know that the information has been disclosed in violation of a duty or confidence, and in exchange for a benefit to the tipper, or where the information is obtained from public sources. The government may prove that Mr. Martoma acted knowingly in either of two ways. First, this element may be satisfied by evidence that satisfies you beyond a reasonable doubt that Mr. Martoma actually was aware of a particular fact. Alternately, Mr. Martoma's knowledge may be established by proof that he deliberately closed his eyes to what otherwise would have been obvious to him. If you find beyond a reasonable doubt that Mr. Martoma's ignorance was solely and entirely the result of a conscious purpose to avoid learning the truth, then this element may be satisfied. However, guilty knowledge may not be established by demonstrating that Mr. Martoma was merely negligent, foolish, or mistaken. If you find beyond a reasonable doubt that Mr. Martoma was aware that there was a high probability that he obtained information that had been disclosed in violation of a duty of trust and confidence, but deliberately and consciously avoided confirming this fact, then you may find that he acted knowingly. However, if you find that Mr. Martoma actually believed that the information he obtained was not disclosed in violation of a duty of trust and confidence, he may not be convicted. The question of whether a person acted knowingly, willfully, and with the intent to defraud is a question of fact for you to determine, like any other fact question. Intent to defraud involves a person's state of mind and the purpose with which he acted at the time the act or acts in question occurred. Direct proof of knowledge and fraudulent intent is almost never available. It would be a rare case where it could be shown that a person wrote or stated that as of a given time in the past he committed an act with fraudulent intent. Such direct proof is not required. Knowledge and criminal intent, although subjective, may be established by circumstantial evidence based upon a person's outward manifestations, his words, his conduct, his acts, and all these surrounding circumstances disclosed by the evidence and the rational or logical inferences that may be drawn therefrom. As I have instructed you, circumstantial evidence is of no less value than direct evidence. All right, we will stop there. Let's see what we have for literary practice. This is called Best Cars for Teens. Ready? Here we go. October 19 to the 25th is National Teen Driver Safety Week, a time when the Auto Club reminds both teens who drive and their parents to review what it means to be safe and responsible behind the wheel. Check out the many resources available at AAA, such as the Auto Club Driving School. Learning isn't over just because a teen passes a driver's test. Continue to review with your teen the importance of distraction-free driving, how fatigue and impairment affect abilities, defensive driving techniques, and other critical topics. The Auto Club's Automotive Research Center, ARC, just released its 2014 list of best cars for teens, a tool to help guide parents in the decision-making process when buying or leasing a vehicle for their teen driver or determining which existing family car to let the teen use. In general, ARC recommends a mid-size car with a 4-cylinder engine and automatic transmission and high crash test scores from the National Highway Traffic Safety Administration, NHTSA. A mid-size car is big enough to protect occupants in a crash, but small enough for a novice driver to handle easily. The 4-cylinder engine limits the car's ability to accelerate, and it's hoped the teen's desire to show off. Automatic transmissions are easier to drive and allow a novice to focus on steering, proper speed, and braking. The crash test scores were taken from NHTSA's website. We selected only vehicles that scored the maximum 5 stars overall. Cars not tested by NHTSA as of press time were not included on the list. The manufacturer's suggested retail prices, MSRP, listed are for base model vehicles with automatic transmissions. All right, back to some jury charge practice. Ready? Here we go. Since an essential element of the crimes charged is intent to defraud, it follows that good faith on the part of the defendant is a complete defense. A person who acts on a belief or opinion honestly held is not punishable under these statutes merely because his opinion or belief turns out to be wrong. It is for you to decide whether Mr. Martoma acted in good faith or not. If you decide that at all relevant times he acted in good faith, it is your duty to acquit him. The law is not violated where a defendant acted in good faith and held an honest belief that his actions were proper and not in furtherance of any illegal venture. I want to caution you in this regard that Mr. Martoma has no burden to establish the defense of good faith. The burden is on the government to prove criminal intent and consequent lack of good faith beyond a reasonable doubt. If you find that Mr. Martoma was not a knowing participant in the scheme and lacked intent to defraud, you must acquit him. To summarize, if you find that Mr. Martoma was not a knowing participant in the scheme and lacked intent to defraud, you should acquit him. On the other hand, if you find that the government has established beyond a reasonable doubt not only the first element, namely the existence of a scheme to defraud, but also this second element, that Mr. Martoma was a knowing participant and acted with intent to defraud, you should go on to consider whether the government has established the third element, use of an instrumentality of interstate commerce, beyond a reasonable doubt. See third element, use of instrumentality of interstate commerce. The third and final element that the government must prove beyond a reasonable doubt is that Mr. Martoma knowingly used or caused to be used an instrumentality of interstate commerce, or used or caused to be used a facility of a national securities exchange in furtherance of the scheme to defraud. The term instrumentalities of interstate commerce means instruments, devices, and means of conducting trade, commerce, transportation, or communication among any two states. Instrumentalities of interstate commerce include the use purely within one state of a telephone or any other instrument used to conduct interstate communication. I instruct you that the New York Stock Exchange is a national securities exchange. The phrase facility of a national securities exchange includes any property or services maintained by the New York Stock Exchange. The government need not prove that Mr. Martoma directly or personally was involved in any use of an instrumentality of interstate commerce or use of any facility of a national securities exchange. It is enough if you find that Mr. Martoma, by his acts, directly or indirectly, initiated the steps or aided, abetted, counseled, or induced others to initiate steps that resulted in a chain of cause and effect, resulting in the use of an instrumentality of interstate commerce or use of a facility of a national securities exchange. This includes placing an interstate phone call or placing an order with a brokerage firm to buy or sell a security. It is not necessary that communications over an instrumentality of interstate commerce contain any fraudulent material or anything criminal or objectionable. The matter communicated may be entirely innocent so long as it is in furtherance of the scheme to defraud or fraudulent conduct. The use of any instrumentality of interstate commerce need not be central to the execution of the scheme. All that is required is that the use of any instrumentality of interstate commerce bears some relation to the object of the scheme or fraudulent conduct. F. Venue. In addition to the foregoing elements of securities fraud, you must consider the issue of venue, namely whether any act in furtherance of the unlawful activity occurred within the Southern District of New York, which includes Manhattan. In this regard, the government need not prove that the crime charged was committed in the Southern District of New York or that Mr. Martoma was present here. It is sufficient to satisfy the venue requirement if any act in furtherance of the crimes charged occurred within the Southern District of New York. try some literary material. This is called Auto Whiz Kids. Ready? Here we go. Whether you drive a hybrid, electric vehicle, or regular gasoline car, you're bound to run into glitches from time to time, and with the increasing number of new makes and models on the road today, the demand for skilled automotive technicians is greater than ever, but even mechanics who work on the complex computer systems in today's luxury vehicles learn the basics at some point. For 65 years, the Ford AAA Student Auto Skills Competition has encouraged high school students to pursue careers in the automotive field. The annual challenge begins with a written exam. Some 1,300 competitors who were enrolled in automotive technology courses took this year's test. Those with the highest scores are placed into two student teams. The top teams, usually about 10, advance to statewide competitions that task the students with diagnosing and fixing a bugged vehicle as quickly as possible without compromising on workmanship. The winning team from each state moves on to the national finals held in June at Ford World Headquarters in Michigan. At the finals, the 50 teams face a second written exam and a similar physical challenge of fixing bugged mechanical issues on a provided vehicle, such as a blown horn fuse and a wiper switch malfunction. Although automotive repair has been considered primarily a male-oriented field, the Ford AAA Student Auto Skills Competition reports an increasing number of females taking interest. This year, 725 girls registered for the event, the highest number of female registrants to date, and 319 of them advanced to the statewide competitions. The Auto Club congratulates all of this year's participants, especially Anthony Newby and Daniel Cabiza Ramirez from Lompoc High, along with their instructor Michael Johnson, who were the runners-up in the statewide competition. Students from Northern California represented our state at the national finals. Students from Grafton High School in Grafton, Wisconsin took home first place. Back to some jury charge. Ready? Here we go. Such an act would include, for example, the placing of a telephone call to or from the Southern District of New York, or the execution or settlement of a securities trade within this district. As to venue, alone, the government's burden is not proof beyond a reasonable doubt. Instead, venue may be established by a preponderance of the evidence. A preponderance of the evidence means more likely than not. If you find that the government has not proven venue by a preponderance of the evidence, then you must find Mr. Martoma not guilty. G. Willfully causing a crime. A defendant may be convicted of a substantive offense if he willfully caused an act to be done which, if directly performed by him, would constitute a crime. Section 2B of Title 18 of the United States Code reads as follows: whoever willfully causes an act to be done which, if directly performed by him, would be an offense against the United States is punishable as a principle. What does the term willfully caused mean? It does not mean that the defendant himself physically committed the crime or supervised or participated in the actual criminal conduct charged in the indictment. For the offenses charged in counts 2 and 3, the meaning of the term willfully caused can be found in the answers to the following questions. Did Mr. Martoma possess material non-public information? that he knew had been provided by an insider in violation of a duty of trust or confidence and in exchange for a benefit? Did Mr. Martoma intentionally cause another person to execute the securities transaction charged in that count based on that material non-public information? If you are persuaded beyond a reasonable doubt that the answers to both of these questions is yes, then Mr. Martoma is guilty of the crime charged in that count, just as if he himself had actually committed it. All right, we'll stop there, and that will conclude our literary and jury charge practice.